Good morning. My name is Sarisha Ganta. I'm a staff attorney with the Pro Bono Partnership of Atlanta. And today we have Lynn Wilson, partner from Morris, Manning & Martin, here with us to speak about Leasing 101. It all begins and ends with the lease. The focus of this webcast is to assist our clients who have their own clients and they assist with housing. So Lynn's going to walk us through some lease provisions that you should keep in mind as you're helping your client sign a lease. A little bit of background about the Pro Bono Partnership of Atlanta. Our mission is to provide free legal assistance to community-based nonprofits that serve low-income or disadvantaged individuals. We match eligible organizations with volunteer lawyers from leading corporations and law firms in the Atlanta area to assist the nonprofits with their business law needs. If you're interested in becoming a client of our organization, we serve 501c3s, focusing in Atlanta or headquartered in Atlanta and the metro area, that serve low-income or disadvantaged individuals and are otherwise unable to afford legal services. If you'd like more information about our organization, please visit our website, and there you'll also find a wealth of resources, including past webcasts. This webcast today with Lynn will also be there soon, and you'll find other articles and great resources for your organization. And a quick disclaimer, please keep in mind that today's information is just to provide general information, general guidance. It is not specific to your organization. So if you do have specific questions, please reach out to your attorney. Thank you for joining us, and thank you, Lynn, for speaking to us this morning.
Thank you for having me. All right, good morning. My name, as it has been told you, is Lynn Wilson, and I'm a partner with the law firm of Morris, Manning & Martin. A considerable portion of my law practice involves residential leasing matters, including drafting and interpreting leasing documents, representing landlords and tenants in leasing disputes, and finally representing landlords in dispossessory actions. So, as you'll notice as we go through the slides of the presentation, I have a close relationship with old albums and music. Some of you aren't going to recognize any of the albums nor any of the groups, and for that I apologize. Others of you will say, oh, this is awesome. So enjoy it as you will as we go through, and I look forward to any comments you might have about my penchant for old music. So as lawyers, we are taught from the first year we go to law school to rely on the written word. And when the written word is transformed into an enforceable signed contract, it is essential that the parties understand the rights and obligations contained. I completely understand, we all do, the desire we have to secure housing for our families, and that often leads to a lack of attention to the details of a lease agreement. As I understand the audience today, you're charged often with the responsibility of advising clients on leasing and housing matters, thereby trying to get your client to zero in on the details. I'm going to try and provide you information you need to provide counsel to your client that facilitates their making sound decisions regarding housing choices. And I'm going to offer my own disclaimer, because I am a lawyer and I can't speak without disclaiming that I'm not here to make you an expert in residential leasing matters. This is only intended as a guide to the general rights and responsibilities of the parties to a lease agreement. I can't cover every scenario which may be applicable, and most importantly, Georgia statutes and case laws are always evolving. So what the application of the law might be today, it may be very different a year from now. All right, so let's move on to slide 3, tenant due diligence. I'm going to take you from the beginning of a potential landlord-tenant relationship through the lease to the end of the relationship, however that relationship may end. And I think it's incumbent, in order to set the lease agreement up that your client may have, to talk for a few minutes about tenant due diligence that you might want to encourage your client to conduct before beginning the leasing experience. The landlord-tenant relationship is created under the law when an owner of real estate gives to another person who accepts the grant of the right to possess and enjoy real estate for a fixed period of time. The payment of rent, surprisingly enough, is not a prerequisite to the existence of such a relationship. An oral contract to lease is valid if the term doesn't exceed 1 year. If it's past a year period, the contract has to be in writing or it violates the statute of fraud. If the lease involved is a sublease, which your client may come to you about, there is no landlord-tenant relationship between the landlord and the subtenant, unless the landlord, by some affirmative action, treats the subtenant as their tenant. And most of the time, that affirmative action would be asking for rent, accepting rent, offering keys, offering to make repairs upon the subtenant's request. I want to speak to you briefly about the nature of the tenancy. The status of the tenancy can become important when the issue of notice and renewal is given by either the landlord or tenant. The tenant who remains in the property after the expiration of a lease or termination by the landlord and who fails to vacate the property becomes a tenant holding over beyond the term. A tenancy at will is created when there's a rental agreement with no set date of termination. For example, if there was a lease agreement for a term, a year, but at the expiration of the lease term, a new renewal was not executed, the tenant then becomes a tenant holding over and a tenant at will. A tenant at will is entitled to a 60-day notice to vacate from the landlord, and the tenant is only required to provide the landlord a 30-day notice of tenant's intention, and this is under Georgia law. There are certain notice requirements. These are notice requirements established by the statute. So let's talk about what we do in tenant due diligence. The most important thing is to ask questions. The lease and the obligations in the lease are enforceable in a court of law. Therefore, before you put your signature on the document or offer any money to a landlord, your client must conduct due diligence on their own. Your client is making a significant decision legally that can impact them for purposes of public records, can impact them for purposes of quality of life. And we want to make sure that they are walking into a new home or apartment completely with the intention of having done all the work that they need to do to ensure they're providing safe and secure housing for their family. So there are lots of simple things that I think it's important that people do. In an apartment context, you want to make sure they're looking over the unit, looking over the buildings, looking over the laundry facilities, looking over what the building is like at night. Is it well lit? If there are neighbors around when they're walking around the development, ask the neighbor, what's it like to live here? Is there crime in the neighborhood? Do you have disputes with your landlord? How does the landlord handle repairs? Things like that. You can't ask a question that won't in the end help you make a determination, your client determination of whether this is the appropriate place for you to live. Never sign a lease or provide a deposit on an apartment or a house until your client has seen the actual unit or house that they will be renting. This is particularly becoming an issue now with the online rental platforms like Zillow and Rent.com and Trulia, because there are independent contractor leasing agents who work for these companies who may know very little about the unit or the apartment or the house. And so your due diligence must include actually viewing the unit or the house that you're considering renting. And keep in mind with regard to the leasing agent that leasing agent's goal is to get you to put down a deposit. I'm not suggesting a leasing agent or property manager will intentionally mislead your client, but the interest of the leasing agent or property manager and the interests of the tenant are not necessarily the same. Your client should inspect the actual unit or property your client will be renting, not online photos, not a model apartment or another apartment in the development. And I will tell you, if the landlord is not willing or the property management company is not willing to show you the actual unit or home, that should be a red flag. And I would suggest your client consider the search. An inside inspection should include looking at the flooring, looking at the appliances, opening the cabinets, looking for evidence of rodent infestation, checking the appliances, turning on the faucets, all the things that you can imagine. One thing I do know that people have a problem with often after renting an apartment is that they discover that the carpet is in much worse shape than what they anticipated, and that's because they're walking on the carpet with shoes on. So my suggestion is that people always run their hands through the carpet. If your hand comes up discolored, that's a sign the carpet needs at a minimum to be cleaned and perhaps replaced. You want to check around the windows and check the heat and AC unit to make sure there's not any water issues. Carry a pen and paper, make a list of everything that's damaged or needs repair. And if the landlord promises to fix anything, get the promise in writing, or better yet, refuse to sign the lease or pay the deposit until the items are repaired. Also, check out the landlord or the property management company. Look on the Better Business Bureau. Look at any consumer protection websites to determine whether there are complaints against the landlord or management company. Ask if the landlord has other properties, and if so, check them out. If the landlord or property management company refuses to provide you a sample lease to review, excuse me, until you submit a non-refundable application fee or approved or pay the security deposit, this is a risk your client should be completely aware of. Most leases follow a general format, and we're going to go through those in general, but you want to ensure that your client is getting the actual terms that they understand that have been represented to them. Also, if your client has requested repairs to the property or the landlord has agreed to make certain concessions, it is essential that all that be in writing and be attached to the lease form when it is signed. My rule of thumb, keep your pen and your money in your pocket until your client is satisfied. The due diligence process is often more nuanced if your client is the recipient of a housing voucher. There are certain requirements the landlord must satisfy in order for a tenant to be able to rent a unit or home and utilize the benefits of a voucher. In addition, during the tenancy, there are mandatory inspections of the property conducted by the housing authority. In some circumstances, the housing authority case manager can also be a very effective advocate for your client. All right, so then the next slide. Although not a part of the lease itself, I want to spend a few minutes talking about application and underwriting. Your client should be aware of the process and the costs. Most landlords charge a non-refundable application fee to pay for the cost of screening of the application, and they also may ask your client to pay an application deposit, which is also refundable if the application is denied. The application criteria should include information that provides your client with an understanding of what they need to be able to satisfy to qualify for the unit or the home. The landlord is going to search criminal history, current income, previous rental history, as well as credit history. Prior dispossessory filings are also going to appear in the public records, and most landlords use third-party searching companies like CoreLogic or ClearStar or Transamerica to run a very thorough check to verify public records. The landlord in its underwriting process will examine all the factors and they'll be weighted according to their own underwriting criteria, which they've previously disclosed to you for your client's benefit. And that will determine whether the application is accepted or rejected. Some landlords in the Section 8 voucher area have a little bit different of an application process, and in most instances the tenant wants to have that voucher in hand before the application is actually made to the landlord. So there's a little bit of due diligence also required on the front end if the tenant, your client, is going to be a Section 8 voucher recipient. All right, so let's look at the next slide. The lease agreement. There are a number of variations of leases that are used in the Georgia market. There's the Georgia Association of Realtor Regions lease agreement, Orthris, which is an independent lease real estate document company. In the multifamily area, the National Apartment Association and Atlanta Apartment Association leases are by far the most common. We now also have a significant number of single-family rental properties in the Atlanta market, and each of those landlord groups, investor groups, usually have their own hybrid lease agreements. They don't use the same lease. And finally, you have the housing authority voucher, which is an addendum to every lease agreement that is entered into between a housing authority recipient, a landlord, and a tenant. So the lease is the playbook by which the tenancy is controlled. And so I can't underestimate, again, harkening back to how important it is to have that understanding of the document before you actually sign and before you sign the lease. Once fully executed, it is a legally binding agreement which provides ramifications for you as a tenant, your client as a tenant, in the event that there are disputes later regarding the lease. So let's look at the nuts and bolts of the lease. We're going to look at security deposit, rent, utilities, pets, landlord's right to renew, and early termination fee issues, the duty to repair, tenant's duty to repair, and tenant default. So taking a look at the security deposit. The security deposit is paid along with a prorated portion of the first month's rent at lease signing. The amount of the security deposit is going to depend and vary significantly across markets. Often in the multifamily space, the security deposit will be very low. As an inducement to prospective tenants who are required to come up with security deposit and rent in the multifamily area, they'll often make the security deposit significantly less than what the market rate might be, also for competitive purposes, I would suppose. Conversely, in the single family market, the security deposit is much higher. This is a reflection of what the owner or landlord perceives the value of the rental, and frankly, the cost the landlord will incur to turn a property at the end of the lease. The move-in inspection is very important. This is the tenant's opportunity to document any existing damage to the property, thereby eliminating it from consideration at the time the security deposit is conducted at the end of the lease. It is incumbent on the tenant to request a move-in inspection. The landlord should have a form they utilize at the inspection, and it should be signed off by both landlord and tenant. The treatment and return of the security deposit is controlled by Georgia statute. The landlord, if other than a natural person, a company, or a landlord that uses a property management company, is required to place the security deposit in an escrow account and provide your client notice of where that security deposit is held at the time they enter into the lease. Now, leases who are in natural persons and who own less than 10 properties are completely exempt from the application of this statute. The tenant is subject to reduction from the security deposit paid for all damages other than those identified in the move-in inspection and other than ordinary wear and tear accepted. At such time as the tenant vacates and relinquishes possession of the property, the landlord is to conduct a move-out inspection. The landlord is to provide a copy of the inspection to the tenant within 5 days of the tenant relinquishing possession, not 5 days from the date the move-out inspection is done by the landlord, 5 days from the date the tenant moves out of the unit. The tenant has the right to dispute the accuracy of that move-out inspection. I'm going to be perfectly honest with you and tell you most landlords ignore the requirement of providing the tenant a copy of the move-out inspection within 5 days of move-out. They, in large part, rely on the language of the statute that provides the landlord must provide the statement of security deposit accounting, which basically shows what they're deducting from the security deposit, within 30 days of move-out. And they provide that with an accounting form and either a check, if you're getting a portion of the security deposit back, or a request for money, if you have your client has incurred damages beyond what the security deposit was. I will caution you also that when I mention the exception from the security deposit application of ordinary wear and tear accepted, this is standard language in all Georgia leases. It's supported by case law. But as you can imagine from the words themselves, ordinary is a very difficult and subjective standard to argue. If the landlord failed to do a move-in inspection, the tenant, frankly, is in a far better position to argue the landlord does not have a baseline to compare the condition of the property at lease expiration, and therefore ordinary wear and tear accepted can really not even be considered. The longer a lease agreement is in effect, the stronger the tenant argument as to ordinary wear and tear accepted being applied to allow them to have more of their security deposit back. But I will tell you, the bottom line is most landlords will find almost any way to keep a majority of the security deposit, because they're going to use those funds as basically an investment toward turning that property for the next tenant. So depending on that security deposit back is probably a foolish thing for your client to do in most circumstances. All right, so let's talk about rent. Rent, rent, and more rent. That's the only way, that's the best way to describe it. And I think the Neil Young song is very appropriate. The rent is always due. The lease requires, most leases require the rent paid on the first day of the month. The GAR and multifamily, which is the apartment association lease, also does not provide for a grace period. Although the late fee doesn't get assessed until the third of the month. So it's a little bit disconcerting, but technically if the rent is not there on the first day of the month, there is a default under the terms of the lease agreement. And I have seen landlords attempt to enforce that language if there's maybe other reasons that they would like to terminate a lease agreement if that tenant has not paid that rent by the first day of the month. Most single family or SFR lease agreements, which is what I call the single family residential rental, typically provide a grace period until the 5th day of the month, at which time a late fee is incurred. There are exceptions. Some do provide that the late fee does accrue exactly on the first day of the month, and those are usually hybrid leases by the mom and pop investor, the less than 10 units and natural person investor that we talked about a few minutes ago. The amount of the late fee is must be defined with specificity in the language of the lease. As a matter of practicality, courts handling dispossessory matters in Georgia will not enforce a late fee that exceeds 10% of the monthly rental. The language in the lease also tells the tenant how the rent is to be paid. In the multifamily lease, the rent is often required to be hand-delivered to the office of the on-site agent, if there is an on-site office. In the GAR and Orthrus lease agreements, the landlords typically delineate how the rent is to be paid by identifying a bank account and a bank. The tenant is to go to the bank to deposit those funds, or via ACH or over the phone, however their banking system works. In the single-family rental space, most require the tenants access an online portal for payment of all rent and fees. It is important to note in the SFR space particularly, and this also applies to any other online portal requirements, that if there is a default in payment of rent, the landlord is going to shut that portal down and not provide the tenant access to the portal to catch those payments up. And I will tell you in full disclosure that that is a recommendation made by attorneys, by me, because in Georgia, if a landlord accepts a partial payment of any amount due, if there is a dispossessory action pending, that dispossessory action has to be dismissed as a matter of law. So if I represent the landlord, I'm going to recommend that that portal be closed, which would require the tenant to cure the amount due in order to dismiss the dispossessory action. The lease will also provide the form of payment allowed. In very few circumstances, the landlord will allow payment of rent with a personal check or cash. And frankly, paying by cash is a risk your client doesn't want to take. And I would never encourage that form of payment. Form of payment typically is ACH, certified funds, or money order. It's important to recognize that if a payment is returned for any reason, the lease will also typically provides a return check fee. And that will also limit going forward the options the tenant has for making payments. If you're advising a client that has an issue with payments that have been tendered by your client but not credited by the landlord, I cannot stress the importance of recommending your client keep copies of money orders or certified funds remitted directly to the property manager. And this is particularly a problem, I think, in the multifamily where there's an on-site office that may have a significant transition or turnover in staff. The burden, unfortunately, is always on the tenant to show proof of payment. And I can tell you from personal experience in court, it can take a significant amount of time for a tenant to track a money order in order to determine whether it was cashed and who cashed it. During this period of time, that tenant is still technically in default under the terms of the lease agreement. So to the extent you can encourage your clients to be very diligent about their form of payments for their rent, I would strongly recommend it, because it will definitely benefit them if the lease does go awry and they need that support later on. I also want to talk about additional charges in the lease that arguably when you sign a lease you might not consider those charges as rent, but they are rent. For example, the late charge, the return check fee charge, those are considered rent. Also, many landlords also charge insurance charges, which is an insurance that technically benefits the landlord, but the tenant pays for it. It's typically between $8 and $10 a month. Some landlords use smart locks, which they charge a service fee for to the tenant. In the multifamily area, there's mandatory pest treatment, which is often charged to the tenant. That's considered rent. If there are any utilities that remain in the landlord's name, for example, in the multifamily area, there's master water meters often, and water is attributed per unit. That's considered additional rent. Also, legal fees in the event the landlord has to initiate any sort of dispossessory action. HOA violation fees in the single family market are also considered additional rent. So my point here is that when your client signs a lease for $1,000 a month, it's not just $1,000 a month that they're probably going to be paying. They're going to be paying additional fees. And in order for your client to be completely aware of what they're getting into with regard to that lease agreement, I recommend that there's be a very clear analysis of what $1,000 at the end of the day is really in most normal circumstances in a month is probably going to look like more $1,100 or possibly even $1,200, depending on what those fees are. Now, if your tenant is a recipient of a housing voucher, a certain amount of money is paid by the housing authority on a monthly basis based on the income, obviously, of your client. That amount will change depending on your client's income. And the tenant in that context has a little bit more protection in the event they fail to pay, keep up that rent. Because if the landlord continues to accept the money from the housing authority, albeit not getting the monthly rent from the tenant, there is some argument that the landlord cannot hold the tenant in default while they continue to accept that housing authority funds. However, the tenant's obligation with regard to any of those other fees as additional rent continues. Now, the account ledger in a housing authority housing voucher rental situation can be very difficult for the landlord, in full disclosure, to keep up accurately because of the way funds come in and funds go out. So my rule of thumb for the protection of a tenant who's a housing voucher recipient is to, on a regular basis, perhaps quarterly, ask both their case manager at housing authority and the landlord to provide them a copy of what their account ledger looks like. This allows your client to have a very clear idea of how those monies are coming in, how they're being attributed, and all the credits that are being reflected. I have had a client, I have a current case actually that's been going on for a couple of years with a client who is a landlord and had a housing voucher recipient in a property, and by virtue of my client's failure of their accounting system, almost $3,000 of utility payments were not credited appropriately to that tenant's ledger, and that tenant woke up one day and saw a bill from their landlord for over $3,000 that they had no idea had not been appropriately charged to them on a monthly basis. That person had been in that property for almost 2 years and had never looked at their ledger. Now, arguably, the landlord had responsibility, but ultimately the tenant had responsibility as well. And because it was such a mess, we're still in litigation over it. But it just reminds you how important it is to be diligent about what that ledger looks like, particularly when there's the third party depositing money into the ledger, and that's housing authority. All right, so let's move on to utilities. The lease will detail the landlord and tenant's obligations with regard to utilities. In the multifamily space, as I mentioned, the landlord will often cover water and assess a flat fee or a metered amount to the tenant on their monthly ledger. In the SFR market, single family, the landlord will only keep the water and sewer in their name if the county requires it remain in the owner's name. The lease will provide the tenant's obligation also with regard to trash, and it is always a charge passed on to the tenant and again considered additional rent on the ledger. The lease will identify whether the unit or property is served by gas or electricity or both, and it is incumbent upon the tenant to establish service in their names. The lease provides that failure to establish service in their names will constitute a default and provide the tenant with the right to terminate the lease or seek a dispossessory action. The landlord is only going to cover the electricity and the gas for a limited amount of time before it's assessed on a ledger as rent due. And we all know that at certain parts of our seasons, the electricity bill can be in excess on a single family of $250, $300, and can be significant in a multifamily as well. So those can be significant charges that can be assessed against your client, which will impact their ability to keep up their monthly rental obligations. So to the extent that your client needs to put those utilities in their own names, I would strongly encourage them to do so. The landlord is required under Georgia law to provide utilities to the property. In the event the tenant fails to connect the utilities, the landlord has to continue the service. But again, it'll be assessed to the tenant on the ledger. And one other important thing to recognize is with regard to that assessment is it's always going to be, almost 2 billing cycles behind. Because the landlord is going to get a bill for April and May electricity, probably not until June. And it's going to hit your client's ledger in July. So there's going to be a lag time that is going to affect those payments of utilities, which is all the more reason why, in an effort for your client to be able to define and determine their financial obligations with regard to their rent and their utilities, to put those utilities in their own names. Now I want to talk for just a quick minute in the single family market about the question of utilities. Using leasing agents, which most of the SFR landlords do in the Atlanta market, the leasing agent may not know whether the property is served by electricity or gas or both. Or they may represent it's all electricity when in fact there's gas service as well. So your client may move in, think everything's fine, and then 3 months later get a bill for $600 for gas, and have had no idea that there's gas service required at the property as well, because it's been paid for and in the name of the landlord up until that point in time. So it is very important that your client conduct whatever due diligence your client can as well in order to determine independently what the utility service for the property is. All right, so now the last thing I want to mention is the landlord cannot disconnect utility services at any time. They can't lock a meter, they can't remove a water meter, they can't call the power company or the gas company or marketer and say turn off the utilities because this tenant has not been paying. They are subject to civil penalties for doing that, and any threat to that should be reported immediately to certainly the consumer protection agencies, as well as, frankly, I would recommend that they call an attorney right away, because that is something that a landlord absolutely cannot do. And it's often used as a threat, to be honest with you. If you don't make the rent payment to pay the utilities you owe me, I'm going to turn off the gas and electricity. Absolutely cannot happen. All right, so let's talk about right to renew and early termination fee. As I mentioned, the lease will provide the term, typically 1 year, although some small investor landlords will often look for 2 or 3 year lease terms in order to keep a tenant in the property as long as possible. The NAIA, an apartment association lease used in the multifamily market in Georgia, typically provides for an automatic renewal of the lease for the same term. So if you're in a 1 year lease, your client is in a 1 year lease, and that lease term is coming up, that lease automatically renews for a term of 1 year, unless your client seeks an early termination of the lease or provides that written notification prior to the renewal period that they do not intend to renew the lease. Now, in the apartment association, that means that your client has to give a 60-day written notice prior to the termination of the initial period of the lease in order for it not to automatically renew. In the multifamily market, the lease does not become month to month. It is renewed for that term as originally provided. The single-family lease takes a very different approach, and most specifically does not allow automatic renewal. The language of the lease provides that the lease expires at the end of the lease unless renewed by subsequent lease renewal. This means at the end of the lease term in a single-family unit, the tenancy becomes a month-to-month tenancy. This SFR lease and the apartment association lease provides that upon lease expiration and the month-to-month status, the landlord can charge a month-to-month fee. The month-to-month fee is often delineated as a percentage of the lease during the term, rental during the term, like 20%, or can be a set fee increase. One particular investor, a very large investor in the Atlanta market, charges a $350 a month-to-month fee across the board, regardless of the monthly rent during the term. Typically, for housing authority voucher recipients, housing authority is not going to pick that month-to-month fee up. It is because, frankly, from a housing authority perspective, they want their tenants in a tenancy that's going to be for a specific term. So they do not pick those month-to-month fees up. And again, it can have a significant impact on whether the tenant is able to keep those monthly rental obligations. And in order to avoid prorated rent, in the event you give your notice but less than 60 days, it is essential that that notice be given prior to the 60-day time period. The last thing I want to mention is a common misconception that people have regarding the end of the lease and that first month's rent and security deposit that you paid at the beginning, your client paid at the beginning of the lease. It is not to be used for the last month's rent. I have heard it 1,000 times that people are under the impression that that rent they pay at the beginning and the security deposit particularly can be used to pay their last month's rent. This is not the case. The tenant is required to pay the last month of the rent for the last month of the lease. Failure to do so will constitute a default under the terms of the lease. The security deposit does not have any relationship to rent, and most agreements, most leases state specifically, in fact, that the security deposit cannot be used for rent. The only exception to this is the tenant who skips, we call it skip, or vacates possession of the property without turning over possession by turning in keys, or if there's a tenant dispossessory that results in a judgment against the tenant. Under these circumstances, the landlord can apply the rent to the security deposit. The question of whether you have the right to terminate, your client has the right to terminate the lease before the end of the term, depends entirely on the language of the lease. Now, obviously, conditions can change for people and they really need to get out of a lease agreement. Most leases do not allow early termination without payment of a penalty. In the broadest sense, the language in the lease says that the tenant can leave anytime the tenant wants, but the tenant has to pay rent for the entire term. Well, obviously, that makes no sense for the purposes of tenant, because you can't pay rent at a bulk amount of rent for the end of for 6 months more of your lease agreement and then try and get into a place to live. So it's a significant concern if you want to terminate that lease early. It's important to understand, though, that the landlord does have a duty to mitigate that damage. The landlord can't say, sure, go ahead and leave, pay me 6 months rent to the end of the lease term, and then the landlord sit on that property and not make any effort to rent it. They have to make an effort to mitigate those damages. And in fact, if they rent it, they can't also collect the rent from the tenant that has terminated early. If in a single family context, if there's an early termination, the landlord typically requires 1 or 2 months rent paid as a liquidated damages, if you will, for the termination, and also that 60-day written notice that we've talked about. In the single-family market, the landlord sometimes will refuse to allow an early termination despite being the tenant offering to pay the early termination fee. And this is because in many single-family properties, they are located in subdivisions where there's homeowner associations, and those homeowners associations more and more frequently have leasing restrictions that only allow a lease to occur on a property once a year. So that's something, in due diligence, your client may also want to look at if it's a single family unit, if it's in a property that has a homeowners association. Sort of look at those due diligence issues too. All right, so let's talk about right of access to the property. Basically, the landlord can come in whenever the landlord wants to. And whatever the landlord finds, the landlord can do whatever it chooses to do with. For example, if the landlord finds that there's criminal activity or reason to think there's criminal activity, or the condition of the property has been altered, or the condition of the property for whatever reason is not safe, that landlord has the right to take whatever measures they consider. I did have an instance a couple of months ago where one of my clients entered a property and found that the lower level of the property had been completely converted into a grow house. So obviously, once those kinds of things happen and the landlord's going to take steps to protect their asset, meaning the house, as well as, frankly, whatever other risks they perceive might happen. In the AAA, Apartment Association, multifamily context, the landlord can always enter, whether you're home or not. If you're home, they're going to try and knock. If you're not home, they're going to come in, do what they want to do, and they're supposed to put a note on your door that says they were there and what they did. I have found that happens occasionally. Sometimes it's obvious they've been there, but if you want to have more control over that notice, you need to make that clear to your landlord that, for whatever reason, I want to be made aware. You email me. Don't just put a note on my door. Send me an email so I understand whether someone's come in the house. In the single family market, it's entirely the opposite. The landlord perceives no right of entry unless the tenant is actually present in the property. And this is, I think it's a reflection perhaps of the fact that it's a single family residence, but every investor that I have done work with in the single family market looks at it in that respect. But this can have somewhat of an adverse effect on maintenance issues in the single family market, because the landlord is not going to send maintenance people in to do work at the single family residence unless the tenant's there. And it is often hard for a tenant to give up time at work or have missed appointments for maintenance in order for it to be done. So it's something that could be a bit more difficult than initially thought of. So let's talk about the next issue, which leads us right into maintenance and repair. I'm going to tell you, if there's one issue in the area of leases and landlord-tenant work that is the most difficult, it's the issue of maintenance and repair. The interests of the landlord and the interests of the tenant are so completely dichotomous when it comes to maintenance and repair that if a lease is going to go south for any reason other than payment of rent, it's on the basis of maintenance or repair issues. Your client lives in the property and has an expectation that it will be maintained correctly and all systems functioning. The landlord, on the other hand, wants to avoid the property becoming a money pit of maintenance and repair expenses. In the multifamily context, the on-site maintenance manager is schooled very frequently that they need to try and make repairs at the least expense to the owners, at the least requirement of needing permitting and licensing, because that ratchets up the expense significantly. So consequently, in the multifamily, you're going to get the on-site maintenance manager trying to do work that quite possibly should be done by someone else. And in an effort to get the repair issue fixed to the point that it's usable, rather than fixed in the way that it should be fixed. And I can't give you anything to tell you what, frankly, to do about that, other than the fact that your client should be aware of and keep track very clearly of maintenance work that's done in the multifamily and who's doing that work. You can always report to code enforcement about a maintenance person doing work that your client may believe very strongly should have been done by a licensed plumber or a licensed electrician, and that's particularly true if there's work being done on heat and AC unit inside inside your apartment. Now let's talk about the law for just a quick second when it comes to the issue of repair and maintenance. Georgia, as opposed to most other states, does not have a statute that provides a tenant with a warrant of habitability. There is case law that provides a tenant with an implied warrant of habitability, and therefore the landlord has an obligation, even if it's not in the lease, to make repairs. But the repairs that most cases consider covered by this implied warrant of habitability are major structural repair issues like electrical and plumbing, things like working dishwasher, repairing toilet innards, which I know is not a technical term, but it's the only word I can think of for what that is, will be set forth in the lease as to whether it's the tenant or the landlord's responsibility to repair. The lease also obligates the tenant to maintain and keep the property in good repair. And the tenant does take possession of the property as is, which is an important thing to recognize as well. The tenant's responsibilities include keeping the property clean, having to do with pest infestation issues, dusting and replacing air filters, affecting the heat and AC in the unit, and also avoiding high humidity and excessive moisture issues in the property. And I will tell you, the landlord will not hesitate to charge back to the tenant a maintenance fee if the landlord is able to argue the tenant has failed to maintain the property, resulting in a non-functioning furnace or AC, or a plumbing backflow because something's been put in the toilet that shouldn't be there, or any number of other issues. And that chargeback will be considered additional rent per the language of the lease. Now, that multifamily leases typically require maintenance requests be submitted in writing via an online portal, and failure to submit those requests in writing will delay the work required. In addition, the leases very clearly delineate what is considered an emergency. Other than a flooding that requires attention, the repair request is always to be submitted via normal process. The lease specifically, a single family investor client of mine, their lease specifically provides that non-working AC is not an emergency. Now, I will tell you, I take issue with that because living in Georgia, knowing that it can be 90 degrees in May and stay that way until October, it is an emergency if I have a family and young children and I don't have any air conditioning. And in fact, most courts that I'm in, the judges hold that same position. But it is important to understand that the language of the leases, and this is common in the single family realm, is that heat and AC is not considered an emergency maintenance item. Now, the language in the leases also, I think it's important to understand that in all the leases, whether it's the multifamily or the single family lease agreements that are used in the Atlanta market, the language states that the landlord has a responsibility, an obligation, not a responsibility, an obligation to make repairs as reasonably necessary as required by law, and will respond to maintenance requests with reasonable promptness after tenant has submitted. Now, obviously, the use of the word reasonable is entirely leads to a subjective determination of what's reasonable, and your client needs to understand that there isn't a hard and fast rule as to when those maintenance requests are going to be dealt with. And in many instances, it's going to be longer than they think it should be. The work may not be exactly what they want, or it might be a stopgap, and whatever the system is will break down again in a couple weeks. My strongest recommendation to your client is that every maintenance request is done pursuant to their landlord's requirements, i.e. on the portal or written request, whatever their process is, that if your client is not getting a response, that they continue to make those requests. The one thing your client can't do under Georgia law, because there's no relationship between rent and maintenance and good repair, is hold their rent as an inducement for that landlord to get the repairs done. This obligation to pay rent and the obligation for a landlord to conduct maintenance repair are completely separate obligations under Georgia law. And I see this so frequently, and I think it's in part because your client gets to the point where they're like, I don't know how else to get the landlord's attention, so this is what I'm going to do. And I completely understand that that would be the perception, but unfortunately what that will do is put your client and the landlord in an immediately adversarial position. So my recommendation is to continue to attempt to make those context with the landlord about what needs to be done, document what needs to be done, and if necessary, if it's a housing voucher recipient, reach out to housing authority, because they will also be your advocates because of their inspection requirements under the housing authority contract the landlord entered into. And in some circumstances, they will even abate the rent due if there have been failures of inspections and the landlord refusing to make repairs that need to be made. All right, so I want to talk for just 1 second about the two most prevalent repair and maintenance issues in Georgia now, and those are mold claims and bed bug infestations. Those are very common. They require, in most instances, that the landlord do very extensive disclosures when they provide you the lease agreement. When your client gets the lease agreement, review that language very carefully to determine what steps the tenant, your client, needs to take to avoid infestations of bed bugs, as well as high moisture and mold issues potentially in the property. If there's any concern that your client thinks those things are the landlord's responsibility, they should seek counsel immediately and not try and work those things out with the landlord, because the landlord perceives those as high value, probably litigation matters, and they will get a response very quickly. All right, so pets are not allowed unless there's an addendum to the lease that provides that. And service animals and support animals are allowed under certain circumstances, well, most circumstances, but the landlord is going to require some proof, oftentimes, of the basis for the service and support animal, and that also can include a letter from a doctor. It won't disclose what the condition is that leads to the need, but it will ask for an affirmation from a physician that a service and support animal is necessary. So the last thing I want to talk about very quickly is default. I think we've run through pretty clearly what all the potential defaults are. Failure to remit payments, defaults in any other condition of the lease, for example, unauthorized pets, using the property for criminal purposes, or any other kind of violations. The last thing I want to mention is that Georgia law, unfortunately, does not recognize financial hardship as a defense in the event that there is a default under the lease. It is just flat out not a reason the landlord or a court will allow a tenant to remain in the property. Therefore, it is incumbent upon your client, in the event that there is a rent default, my recommendation is that there be as much communication as possible with the landlord to try and work those issues out. If there is a default and there is legal action taken, there are many resources your client can use to help them through that legal process. My contact information will be available, as well as I know Legal Aid does a considerable amount of work, and the Atlanta Volunteer Lawyers Foundation, I think, also does some work assisting your clients in the event they get in that situation. The final thing to say is, if there is a dispossessory action filed, it is imperative that your client respond, not ignore it, because under Georgia law, if your client does not answer the dispossessory, the client loses the right to a hearing in front of a judge regarding whatever issues have caused that dispossessory action to be filed. And I think that's all the time I have, and I appreciate your consideration. Thank you.
We do have a few questions. What should you do if the landlord says one thing verbally before you sign the lease, but then later on you look in the lease and it says something different?
The written document is going to control, and that's why I mentioned at the very beginning that the lease is the enforceable contract. Now, I will say that, and that's the reason why you want everything in writing. You don't want to rely on any verbal representation by the landlord. I will say that if you get in a situation where you're actually in a court hearing about it, if you've got witnesses or you've got evidence that you can establish that says this is what the landlord said, that will put you in a different position. But without it in writing and as a part of the lease agreement, you're in a tough spot.
So if they say one thing, you should try to get that changed in the lease before you sign it?
Yes.
To match up. Okay. And you mentioned month-to-month fees.
Yes.
Is that written in the lease too?
Yes.
Or is that something final?
No, it will be in the lease agreement. It will say what the lease month-to-month charge will be once the lease has expired. It may be a percentage, and it may be a fixed amount, depending on the lease agreement.
And one more, you mentioned several times about utilities that might be charged back to the tenant, but
Yes.
they don't know about it
Yes.
so much later.
Yes.
Can something be put in a lease that says that the tenant will be notified in, like, within a month or within a 2-month period?
What you could request in the lease in a special stipulation is that, number one, the landlord tell you what utility services there are at the property, and two, that the tenant will receive a copy of the monthly utility if the landlord keeps it in their name within a certain period of time after receipt. A lot of times the tenant doesn't even get a copy of the bill. It just shows up on their ledger as a charge. So certainly getting a copy of the bill would help that.
Okay. And that is all the questions that we have for now. Thank you, Lynn.